Today's topic is our first in the F-Tag series, turning deficiencies into efficiencies, and we're going to be hearing about F550, residents' rights and guardianship. My name is Constance Tetrov, and I am a Quality Improvement Advisor with Superior Health Quality Alliance, and I am accompanied by a few of my colleagues, Tabitha Meyer, Mykesha Plesko, as well as our guest speaker today, Margaret Chamberlain. We host these one-hour sessions on the second and the fourth Wednesday of the month. The first half is a didactic presentation, then the remaining time will be for Q&A. The PowerPoint presentation link will be dropped into the chat momentarily, and please use the chat box to share any comments, questions, and even resources during the presentation. Besides learning from our speakers, we learn from each other and our peers. Towards the end of today's event, we will also put an evaluation link in the chat that will take only 1 to 2 minutes to complete, and we use your evaluations to help us give you a better experience. Today, we have Margaret Chamberlain, who is General Counsel at Majestic Care. She is an alumnus of Cooley Law and has nearly 30 years of experience in representing clients in the healthcare industry with a focus on post-acute care providers and supporting clients dealing with state and federal regulatory agencies, state and federal enforcement appeals, developing corporate compliance programs, state general licensing and/or criminal investigations, Medicare and Medic and Medicaid, civil and criminal fraud concerns, and professional licensing. Ms. Chamberlain has sat on various boards, including formerly sitting on the Board of Improved Health for 8 years, which is a part of the Superior Health Organization, and currently sitting on the board of Recovery Alleys of West Michigan, an organization that promotes multiple pathways to recovery, and Our Hope, which offers recovery to women who seek healing from the disease of an addiction. Ms. Chamberlain also works with Leading Age of Michigan on the Public Policy Task Force and on the Healthcare Association of Michigan, HCAM, Legal Regulatory Committee. Welcome, Ms. Margaret Chamberlain, and we look forward to you sharing your profound experience with us today. Okay, let's get started. The floor is all yours.
Thank you for that introduction. That was fun to listen to, I guess. So I understand that this presentation is about the federal regulations regarding guardianships, and so I wanted to focus a little bit because it does vary from state to state. You know, guardianship and surrogate decision making varies from state to state, and one of the things that I thought I would focus on, because it always seems to be the sticking point, especially with Michigan, is who has authority to make what decisions. And it almost always, the sticking point almost always comes down to who can make life-sustaining treatment decisions. And this is a really interesting topic, especially when you start comparing states, because it's not so much a matter of what the regulation says or what the state law says, but how it's interpreted in the state. And so this is a really interesting area to explore how that actually works. And in putting this presentation together, I've given presentations over and over again, for Michigan, because Michigan is an outlier when it comes to surrogate decision making. So I've given a lot of presentations on that, and I am going to focus on Michigan. But in focusing on Michigan, I'm also going to touch on the other states, Wisconsin and Minnesota, because it'll be interesting to compare and contrast how those differ between the 3 states. So that being said, okay, I'm going to see how, bear with me. Look at that. Okay. So the objectives of this presentation is that I do have participants who understand Michigan laws on advanced directives, but really, while I am going to focus on Michigan, I am also going to touch on Minnesota and Wisconsin, but in a compare and contrast manner so that we can see how they differ from state to state. But I'm going to use Michigan as the fulcrum for that discussion. The hope is that participants will be able to identify legal decision makers, and that participants will be able to identify the scope and authority for the legal decision makers. We all know about the Patient Self-Determination Act, or at least I hope we do. And and that is the federal law. It came under OBRA, and it requires facilities to inform residents and legal representatives of state laws regarding advance directives. This is true no matter what state you're in. It's also applicable not just with nursing facilities, but with doctors' offices and hospitals, and any place where an individual touches a healthcare provider. They really should be getting information on their advance directives. I suspect that that's not always what's happening, but in an ideal world, by the time that an individual gets to a skilled nursing facility, they will already have an advance directive in place. But I think that that's an ideal, and hopefully we can get there. But it's always good for skilled nursing facilities to reach out to their hospitals and the referral sources that they are working with to encourage advanced directives to be done before they get to the skilled nursing facility, because by that time things can get a little confusing, and we will talk about that. You always want to document the provision of the information on the advanced directives that you've given to a resident, and that must be reviewed annually to make sure that individuals still feel the same way about. It doesn't mean that the advanced directive expires, but it simply means that you should be reviewing it as a facility to ensure that your residents' wishes are being upheld. So here's where I'm going to kind of cover the state laws. Interestingly, Michigan does not have a living will statute. That doesn't mean, and we'll talk about this. I have a lot of slides in this presentation. I'm gonna fly through a bunch of them because it'll be more of a takeaway for you. But I want to make sure that I'm comparing and contrasting appropriately here. Michigan does not have a living will statute. That doesn't mean we don't allow them or they're not recognized. It simply means that we don't have a statute that says this is what it looks like, this is what it has to be. We do have case law that talks about what will be upheld and what won't be. So I encourage you to listen for the terms clear and convincing evidence. So a living will it would be upheld if there is clear and convincing evidence of what the person wanted. And clear and convincing evidence, as we will talk about later, is really something in writing. The courts in the cases have suggested that it's insufficient to simply say, I was at a birthday party with mom and she said that I would never want to be on a feeding tube. That's not necessarily going to be clear and convincing evidence. They would prefer to see something in writing. And so when you think about that, it should be something in writing. That's where the living, some document that's labeled living will could then be interpreted as clear and convincing evidence of what the person wanted. So Michigan is one of only 3 states that authorize the appointment of a healthcare agent only. So we have a statute that authorizes durable powers of attorney for healthcare, and the patient advocate under that durable power of attorney for healthcare is what we recognize because we don't recognize by statute living wills. And while Michigan does have technically a surrogate statute, meaning, if you don't have a patient advocate appointed, if you don't have a power of attorney, Michigan has a statute that allows for a surrogate. But the surrogate does not have a hierarchy, which makes it extremely difficult to actually operationalize in a facility, because it simply says that, and we'll talk about it more specifically later, it lists a whole bunch of people, a spouse, an adult child, a individual serving in loco parentis, which means just the person who happens to be there at the time who is taking responsibility. It lists a whole bunch of people, but it gives no order of priority. So you theoretically could have 6 people walk in, all claiming to be a surrogate, and there would be no way to differentiate who actually would have priority for, being the actual for being recognized as the surrogate. So it has some operational issues. Interestingly, Minnesota, it does, like Michigan, it recognizes do not resuscitate, as Michigan does. It recognizes the pulse, as Michigan does. It recognizes living wills. It does have a statute. It has advanced healthcare directives, which might go beyond end of life care. So I'm going to focus on end of life care here, but know that there is a statute out there that talks about advanced healthcare directives, and it could cover things other than, do you want a feeding tube? Do you want CPR? And then they also have power of attorney for healthcare, which Michigan does. Interestingly, Minnesota does not establish a hierarchy of who should make healthcare decisions, kind of like Michigan, but it does. Most facilities have a legal and ethics team that tries to find someone closest to the patient, but it doesn't even have to be a family member. So they're they have no natural surrogate hierarchy, as it's likely called, something that predetermines who could be a surrogate decision maker for a person. But often they do have a process where they can look at next of kin, the person's spouse, domestic partner, adult children, parents, adult siblings, adults, grandchildren, a significant other, a close friend, or another relative. And so usually the way Minnesota does it is they can have an ethics team that looks at who is the person who's closest to this individual, even though there's no specificity in a statute that says this is the process that's supposed to be followed with that. But it's good to know that there is a process that Minnesota recognizes to do that. Wisconsin also recognizes power of attorney for healthcare. It has what they call a declaration to physicians, which is the Wisconsin version of a living will. They have do not resuscitate orders, as Michigan and Minnesota do. They have the PULSed, which Michigan and Minnesota do. Michigan is, I think, the newest to the PULSed. And they also have no surrogate hierarchy except for family members and friends under certain limited circumstances can admit individuals to hospice or from hospitals to nursing homes, but it doesn't give authority. So, for example, to make life-sustaining treatment decisions, it is strictly for admission to facilities. And in Michigan, even because of the way our surrogate hierarchy is set up, and because of if somebody comes into a facility that has no advanced directives, no living will, no durable power of attorney for healthcare, even admitting a resident to a facility can be complicated because we don't have a recognized process like Wisconsin and Minnesota do for that process. That is touchy. So in Michigan, I will say, keep in mind that I'm focusing on Michigan here. The living will is not technically an advanced directive because there is no statute. It can be recognized for, if someone has a living will, it can be recognized under certain circumstances that we will get to, but technically it is not an advanced directive in Michigan. It would be in Minnesota and it would be in Wisconsin. In Michigan, we often have things like treatment preference sheets. I don't know if that's the case in Wisconsin or in Minnesota, but treatment preference sheets are, someone comes in, they fill out, do you want to be resuscitated? Do you want a tube feeding? And oftentimes I find that those are filled out by individuals who have no legal authority to be making those decisions. And that treatment preference sheet is not an advanced directive. It oftentimes doesn't have the appropriate signatures. It oftentimes does not have the physician signature. It is a document that has been created by the facility for decision making, but it really has no legal value. And so I think I would just say word of caution. Creating things like that, while they might be helpful to have something as a face sheet in the front of the charts, you often run the risk of violating a resident's rights because it's not really being done by the appropriate person, the appropriate legally responsible person, and it really doesn't have the force of law because of the way that it's set up. Sometimes they can be used as clear and convincing evidence, as I said previously, as a written document. If it's signed by the resident, maybe witnessed, you might be able to use it. And sometimes it can be used in combination with other legal authority to determine what the resident's wishes really are. So they could be, beneficial, useful evidence for a judge, to, if there is a question about what the resident did or didn't want. So who can make healthcare decisions for a person? Always first is the resident. The resident always has the right to make their own decisions if they're able to do that. And most states have now, and CMS encourages allowing residents to make the decisions that they are capable of making. While they may not be able to make, there's no longer any idea of someone's competent or not competent. And I think, probably most of us on this presentation understand that there's a spectrum. You have people that absolutely do not have the ability to make decisions, and then you have the people that absolutely do have the ability to make decisions, and then there is a wide range of people in between who can make decisions, and sometimes that may change throughout the day. You may have people at 3 o'clock in the afternoon who are perfectly capable of making a decision that they could not make at 9 o'clock in the morning. And it's incumbent upon us to make sure that we're documenting, the residents' abilities, even if they change throughout the day. But allowing the resident to participate in the decision-making process as much as possible. CMS has really emphasized that, giving as much autonomy to the resident as possible as determined by their cognitive status at the time. So always look to the resident first, even if there is a durable power of attorney, even if there is a legal guardian, or otherwise, because you want to be able to demonstrate that you're allowing the resident to help in that decision-making process. And I don't think this changes much from state to state. If you have durable power of attorney for healthcare or patient advocate or whatever the state, whatever they call it in that state. And then we also have legal guardians, and then a judge can also make decisions for somebody, obviously. We're not going to argue with the judge. So the federal regulations clarify the resident's right to designate a representative. It makes clear that court-appointed representatives or legal surrogates have the right to make decisions for the residents. It includes same-sex spouses if the marriage is valid in the jurisdiction where it was celebrated. It's intended that facilities do not afford more decision-making authority to a resident representative than is intended by the resident or permitted under applicable law. So again, there's that making sure that we're not, it's not an all or nothing, that we're including the resident as much as possible. It emphasizes person-centered care and the role of the resident and individuals identified by the resident to be actively involved in the care planning process. So I do want to point out that depending on the state, and it sounds, and I don't think any of our states have a surrogate hierarchy necessarily, but I wanted to be clear that simply because someone identifies as the resident representative, the responsible party, the husband, the wife, the mother, the father, the surrogate, the friend, the dog, just because they say that's what they are, doesn't necessarily automatically convey authority. And the reason I put this in here is because it is extremely important as the people who are caring for the residents in the facility to support their rights, that we're making sure that whoever's making decisions for the person has the legal authority to do that. So reading the paperwork that's given to you, making sure that it clearly states, the scope of, and I'll back up here a little bit. Just because a document says that it is, for example, a durable power of attorney for healthcare, just because it says that at the top doesn't necessarily mean that's what it says in the body of the document. And I will tell you as an attorney that it's usually attorneys who mess this up. And so anytime you get a document that says durable power of attorney for healthcare, you need to make sure that that's exactly what it says in the body of the document, and that it's not just a financial durable power of attorney, or that it limits the healthcare decision-making in some way. And that becomes very important in Michigan, which I will talk about. So with our residents, we always want to look for legal authority when the resident comes in the door. Are they competent or capable of making decisions? If the resident is competent, no one else has authority to make healthcare decisions for that resident. I know sometimes residents will often say, oh, and my mom does this to me, I want my daughter to make decisions. I want my daughter to make decisions. And that's fine. We can do that, but it doesn't mean that we should automatically then from that point forward turn to the daughter if the resident is capable of making decisions. We always want to document that we went to the resident first, and they can always say, I want my daughter to make that decision. So being very clear that, you know, we're respecting the resident's rights each and every time that we're approaching about a decision. Again, we want to make sure that we can support that, you know, that the resident is making decisions, you know, whether that's by a physician documentation, MDS, mental status exams of some kind. I know there's a lot of them out there. There's the BIMS, the MOCA, the, you know, whatever. But making sure that we can support our decision. And even if the resident's capacity changes throughout the day, we want to be able to back up, you know, the resident's capacity at the time that they're making the decision. So I also encourage, as I mentioned earlier, working with admission sources to get documentation prior to admission, documentation of competence if that's at all possible, even though sometimes that will change dramatically once a person is admitted or once they have gotten improved from the status that they were in the hospital. Making sure that all documents are maintained in the charts that you're assessing annually, and with any change in mental status, positive or negative. I often recommend that it just be reviewed with any MDS, you know, whether it's, you know, an annual MDS or any significant change or something like that, just to make sure that you're catching it. We always want to make sure that while the resident is competent, that we're offering the opportunity to complete the durable power of attorney for healthcare, if possible, suggested living will as additional evidence of the resident's wishes. One thing that I think is missed, an opportunity that's missed is, you know, I hear a lot of feedback from people in facilities that talk about it is a lot. When somebody's admitted to the facility, they're filling out reams of paperwork, and the last thing they want to do is talk about an advance directive. Like, do you want CPR? Do you want a tube feeding? Do you want all these things? Another reason it's good to try and get it before they come in, but also keep in mind that they don't have to make all those decisions. Just because it's on the form doesn't mean that you have to make that decision. Often it's sufficient just to get someone appointed. It's okay for a resident to say, you know what, I'm going to appoint my daughter to make decisions, and I'm going to give them authority to make decisions about life-sustaining treatment decisions, which is an important thing in Michigan. And if you want to circle back around to the other stuff later, you can do that. But at least getting that far with them is often a good thing. And I think we miss that it doesn't have to be, we don't have to boil the ocean all at the same time. You know, we can do it a little bit at a time. So durable power of attorney for healthcare. And this is, I'm going to use Michigan lingo here, but it has comparable lingo from state to state. It's the same concept, you know, that we have to have a patient advocate who's making healthcare decisions, and it's there has to be the relevant paperwork, and it's done by a competent resident. And by competent, that is, you know, as I mentioned, that is a spectrum, you know, when a resident is filling that out. And I will tell you that the courts are very loosey-goosey on that. What, you know, when is a resident competent to complete a will? When is a resident competent to pick someone to make decisions about life-sustaining treatment? The courts give a lot of latitude on that because they think that is something that would be very close to the person. And so if you're ever lacking something to do in your spare time, reading some case law and what the judges have found to be competent for completing wills is off the chains. It's actually very funny. So, Harvard Journey for Healthcare in Michigan. I'm sorry, the patient advocate, we know that that doesn't become effective until it has been determined by two physicians or a physician and licensed psychologist that the patient is unable to participate in medical treatment decisions. And that's the language out of the statute, unable to participate in medical treatment decisions. It's not whether they're competent, it's not whether they have capacity, it's whether they're able to participate in medical treatment decisions. And so I think this is true for across the board, that we often think of it as two buckets. They have capacity or they don't. There's that spectrum. And I encourage people, especially based on the new federal regulations, that we're looking more at, do they have the capacity to make this decision? This often comes up with sexually active residents. Does that resident, just because they have a diagnosis of dementia or just because they have a guardian doesn't necessarily mean that they don't have the ability to participate in that activity. But it would require an assessment as to whether they have the ability to fully comprehend that decision. And I could go on about that. The American Medical Directors Association has a lot of good information on assessments that you can do for that specific issue. But thinking about it in terms of, that it's not an all or none, that it is a spectrum, and some people may have capacity to make certain decisions, but not others. They maybe not be able to balance a checkbook, but they can certainly, pick who they want to be their power of attorney. We want to make sure that, again, the documentation is in place. It's reviewed annually. I always suggest, and it might be on another slide, never take somebody's word that they are the power of attorney or that they are the guardian or that they have legal authority until you actually see it in your hands. Not even just part of it. It has to be the whole thing. You want to actually see it, and you need a copy of it in your records before you recognize it as recognize that person's having legal authority. Sometimes they expire. Sometimes people think they're the guardian when in fact it expired years ago. So it's just good practice to never recognize it unless you actually have it in your hands. So in Michigan, the durable power of attorney has to be in writing, signed by two witnesses. Witnesses can't be immediate family. They can't be a presumptive heir. And basically anybody who's going to benefit by the resident's death financially. And they can designate a successor advocate. I would say across the board that that's a good idea. States have, and this is true for durable power of attorney, it's also true for guardians. I know sometimes places have co-guardians. That can be complicated, when you're trying to discern who to go to. But for power of attorney and for guardians, you can have a successor. Like if, Uncle Jim goes to Florida every year, he might want to have somebody that can take his place. But they can't just designate someone. It has to be designated by the individual who created the durable power of attorney in the first place. So having a successor is a good idea. And as I mentioned previously, look at the scope of authority, make sure that it says what they think it says in the paperwork. Don't confuse with just a power of attorney. A lot of times people think because they have a power of attorney, that means durable power of attorney for healthcare. It does not, because a simple power of attorney does not extend beyond the individual's incapacity. Once the person is determined to be incapacitated, that power of attorney is gone unless it has that durable language in it. In Michigan, you have to give a copy of the designation to the proposed patient advocate. Hold on, I apologize for this. Okay. Paperwork for patient advocate can include a statement of the patient's desires on care, custody, medical treatment. Other states have the ability to do that on their documents. They can limit the scope of what they want or don't want. In Michigan, an advocate can only make decisions that a resident could have exercised on their own behalf. So, and that's true for other states as well. You can't, just because you are the patient advocate, doesn't mean that you can authorize you know, um, something that's not medically necessary or something that would be detrimental to the resident. You have to act within the resident's best interests. The advocate cannot delegate their duties. The whole point, I don't understand why this keeps, I apologize about this. The whole point of having an advance directive is an individual is appointing somebody. So that individual that's been appointed can't then appoint somebody else. They don't have any authority to do that. It can only be the person that's been appointed. If a person has regained capacity to participate in medical decisions, the designation of the patient advocate becomes ineffective in Michigan. And there are no requirements for having two physicians certify that. But I would say that if I was working for an organization and I would want to have that clarified, that would be something that I would want to back up with. If someone has been declared incapacitated or unable to participate in medical treatment decisions, I would definitely want some sort of documentation to support, the getting rid of the the surrogates power to make decisions with some sort of medical backup on that. Patient advocates can't get compensation for their duties. They have to act in accordance with the resident's best interests. So this is very specific to Michigan. The known desires of the patient expressed while the patient is able to participate are presumed to be in the patient's best interests. So if a resident prior to losing their capacity has said in a document, I want to be a full code. They've written it as part of their living will. They've written it as part of their advance directive. And then they lose the capacity to make decisions or they're unable to participate anymore. You cannot change their directive. They will remain a full code because what they put in writing is presumed to be in their best interests. So that's why sometimes it's good, that may be what they wanted when they filled it out without the understanding that that could change later. And so we have to be real careful. And that's why sometimes it's a good thing to just, give the authority to the person who's going to be like, I'm picking my daughter to make decisions for me and she can make them best, based on our relationship as opposed to writing down every little thing. It avoids that problem. A patient can always revoke their designation at any time. A patient advocate can revoke their acceptance at any time. Disputes regarding someone's inability to participate in medical decisions shall be resolved by petition to the court in the county in which the patient resides. So if we can't decide if the resident has capacity or not, that's best taken up by the courts, is what we're saying here. So this here is very specific to Michigan, and this is one of the reasons that Michigan remains an outlier. A patient advocate can make a decision to withhold or withdraw treatment that would allow a patient to die only if that patient is expressed in a clear and convincing manner, and I use air quotes here if you can't see it. So that means in writing, that the patient advocate is authorized to make such a decision and the patient acknowledges that such a decision could or would allow the patient's death. The unfortunate thing is a lot of durable power of attorney for healthcare that are, there's some great ones on the internet from the Bar Association. There's lots of good stuff out there. But there are often ones that are done, and I don't mean to be disparaging, that are done by attorney's office that say durable power of attorney for healthcare that do not have this language in it. And without this language, a durable power of attorney for healthcare, that patient advocate cannot make life-sustaining treatment decisions. So theoretically, they cannot make decisions about do not resuscitate. They can't make decisions about withholding tube feeding, anything that could hasten a resident's death. So make sure you're looking for that language. And there are some great samples of forms out there that specifically call that out in its own little box for the resident to sign. I love that because then there's no question about, that particular, there's no ambiguity about it. Guardianships. This is an individual who's created by petition to a probate court, and this is true in all states. The probate court can appoint a guardian if it's found a clear and convincing evidence both that the individual for whom a guardian is sought is an incapacitated individual and that the appointment is necessary as a means of providing continuing care and supervision of the incapacitated individual. This is where the incapacitated language comes from. So usually you have to show both things. Often guardians are needed because there is a failure to have a DPOA for healthcare or, another type of advanced directive, depending on whether you're in Michigan or Minnesota or Wisconsin. The petition has to specify facts about the individual's condition, specific examples of the individual's recent conduct that demonstrate the need for the guardian's appointment, and you have to come prepared with the documentation from the record and possible witnesses to testify at the hearing. What I will say about guardianships is it not only varies from state to state, but even from county to county on how guardianships are, the process that is followed. I can generally say to anybody living in Michigan, Minnesota, or Wisconsin that it is a good idea to become best friends with your probate clerk, who will walk you through what your probate judge requires and doesn't require in their specific courtroom for getting a guardian appointed, because every judge has their own, they live in their own little world and they have their own ideas about what they want and don't want. So become best friends with their clerk and they will tell you, even though they'll tell you they can't practice law, they will tell you what that judge wants. The court appoints a guardian ad litem, or it might be called something different in other states, but really this is the person who's going to make sure that the rights of the resident are protected during that guardianship process. And they will make recommendations to the court. Usually that person will, come out to a facility, they'll talk to the resident, they'll talk to family members, and they'll help the judge. Their whole role is to help protect the resident and help the judge make a decision on whether someone should be appointed guardian, whether it should be a limited guardianship, what the scope of that authority should be. I'm going to kind of skip by this because a lot of it's not applicable for skilled nursing facilities. One thing that you have to be careful in any state is that when you're doing guardianships, that the notices for the guardianships are served appropriately. Like I said, every probate court, every county is going to have a different way to do that. So again, make sure that you talk to your county clerk about how that particular judge wants it done. Sometimes judges want it done by paper. Sometimes they want it served, individually. So just make sure that you're doing it correctly so that you don't show up in court and the judge says, I'm sorry, you didn't serve notice properly. A patient advocate is, that's been in Michigan, a patient advocate that's been designated by a durable power of attorney for healthcare that was properly executed will take precedence in. So even if a guardian is appointed, if there's already a durable power of attorney for healthcare, the DPOA for healthcare will take precedence. That the judge, anytime a guardianship is appointed, the judge should always be addressing if there is an advanced directive with somebody else appointed, because that is the person that should take priority because it was the person's choice. They always try to support the resident's wishes. I'm going to kind of skip past this. Know that if a guardian is acting inappropriately, not in the person's best interest, you can always move to have the guardian removed, a new one appointed to replace that person. You just have to make sure you have appropriate documentation for that. Going back to Michigan specifically, a guardian cannot make a medical decision to withhold or withdraw treatment that may hasten the incapacitated individual's death unless there's clear and convincing evidence at such decisions prior to the individual's incapacitation. We already talked about that. Except in Michigan, a guardian may be authorized to request a do not resuscitate order. That came out in 2014. It used to be that guardians could not even get a DNR order for their wards. Although, I mean, I don't have time to go into the history of that, but now guardians can request a DNR order. And so it's important, and that process is done by the guardian ad litem prior to the to the guardianship being put in place. And so unless the guardianship paperwork says something differently, then a guardian can request a do not resuscitate order and it will specify the circumstances. I've already talked about this, about the different probate courts. Current DNR laws. I did talk a little bit about this already, revising the definition of do not resuscitate orders in Michigan that will now allow guardians to request do not resuscitate orders where they used to not be able to. I'm going to kind of run through these because I want to make sure I leave time at the end for questions here. And this goes through the process for a guardian requesting a do not resuscitate order. I don't think we really need to cover that here, unless if somebody has a question about it at the end, I'm happy to answer that. But again, what's really talking about here is what the guardian ad litem has, the hoops that they have to jump through in order to tell the judge that yes, it's okay that this person, they have to do a little bit of investigation, and in order to make sure that the judge has the appropriate information to say whether or not, or that a resident cannot have a do not resuscitate order if that's the case. With the Michigan do not resuscitate order, instead of destroying a revoked order, it requires a declarant or patient advocate to write void on all the pages of the order. And if they are wearing a bracelet, to remove that. So that's a little bit different from other advanced directives. So I'm going to okay, this again goes back over some of those guardians being able to, obviously this was an issue when I drafted this, that it was, having to do not resuscitate orders for guardians in Michigan. That was a big deal here because it allowed for individuals to at least get do not resuscitate orders for their wards, whereas in the past in Michigan, because unless there was clear and convincing evidence of an individual's wishes regarding life-sustaining treatment, nobody could make those decisions for somebody. And so allowing this is a step in Michigan that allows at least guardians to get do not resuscitate orders. And it's because of that same language that it is so important that in a durable power of attorney for healthcare, that language that I talked about that's called out onto one slide, that authorizes someone to make life-sustaining treatment decisions, and that the resident understands that such decisions can hasten their death. That's why it's so important that it is on the durable power of attorney for healthcare paperwork, because otherwise it doesn't meet that clear and convincing standard that Michigan has established. So that distinguishes Michigan from some of our other states that are a little more liberal in how they interpret. They don't have those same limitations on life-sustaining treatment in other states that they do in Michigan. So in the beginning, I talked a little bit about how admission to so in Wisconsin, it allows a surrogate to admit certain family members or friends under certain limited circumstances, to admit residents from a hospital to a skilled nursing facility, to get consent to do that. And in Michigan, we also have that authority. So under our Social Welfare Act, which is Medicaid, this pertains to Medicaid residents only. And it states if the person for whom surgical or medical treatment is recommended is not of sound mind or is in condition is not in a condition to make treatment decisions for himself, the written consent of such person's nearest relative, legally appointed guardian, or person standing in loco parentis, again, that could be anybody, just somebody who's taking responsibility, shall be secured before such medical or surgical treatment is given. So while this doesn't necessarily convey authority to anybody, it does create a duty for the provider to get consent. And they're saying that consent can be from any one of those people. So that is typically how I advise clients, and the general consensus is, you can use that for someone to be admitted to your building to say, okay, we can have consent for them to come in in order for us to admit you, we have to have consent. It can be from any one of those people. That really doesn't help necessarily on a long-term basis because there's no hierarchy. It doesn't apply to life-sustaining treatment decisions. It is a little bit of a quagmire long-term. And so in Michigan, we also have a statute called the Michigan Dignified Death Act, and it applies to terminal illness. This is Michigan's surrogate statute. So if you'll remember in the beginning, we talked about Minnesota not having a state law that establishes a hierarchy of who should make healthcare decisions, kind of like Michigan. You'll see here that Michigan talks about a surrogate. Here's Michigan's definition of a surrogate: parent, legal guardian of a minor, next of kin, can be a patient surrogate. So it really can be, there's no hierarchy. It doesn't say it has to be a spouse or an adult child. It just kind of throws it out there. And Minnesota also has a surrogate decision-making, and it doesn't have any sort of hierarchy for who can make decisions, but it does say that, it has a process that is recognized in Minnesota that allows an ethics committee or some process to choose the individual who is closest to the resident to make those decisions. At least that's what I've picked up on Minnesota law. And, I welcome anybody at the end of this to, maybe give a little more detail about how that actually works in practice. But so you can see how, even though Michigan and Minnesota have similar situations, we don't really have a real surrogate hierarchy, but in practice, it functions very differently. So in Michigan, it says that the patient or patient surrogate or patient advocate acting on behalf of the patient has the right to make an informed decision regarding receiving, continuing, discontinuing, and refusing medical treatment for the patient's reduced life expectancy due to advanced illness. So that may make it sound like a surrogate in Michigan can make life-sustaining treatment decisions, because it says refusing medical treatment for the patient's reduced life expectancy due to advanced illness, continuing and discontinuing. That's what it sounds like, except in Michigan, advanced illness, they changed the definition for the purposes of that one small section in the statute. Basically, that before a surrogate can make life-sustaining treatment decisions, it has to be a terminal condition, as is generally recognized by the medical profession. So only when someone has a terminal illness can a surrogate make life-sustaining treatment decisions. But even with that statute, which seems sort of clear on its face, we still have in Michigan a statute. The Michigan Dignified Death Act says that the statute does not create a presumption about the desire of a patient who has a reduced life expectancy due to advanced illness to receive or refuse medical treatment, regardless of the ability of the patient to participate in medical treatment decisions. So case law suggests that a surrogate may still require clear and convincing evidence of a patient's wishes. So it is a risk tolerance, on what your organization would tolerate in terms of what, if you don't have a clear advance directive, if you're relying on a surrogate simply by the statute, what will be your risk tolerance in terms of what decisions you would allow them to make? Because the case law is not entirely clear on that. Michigan Post, I do want to touch on that because it is new to Michigan, even though others, both Minnesota and Wisconsin recognize it. It is a document that is part of the advanced care planning process that includes choices about CPR, critical care, other care. It's intended for individuals who are terminal. It is a guide. So if an advance directive. So if a person can't tell others what to do at that time, it is signed by the patient or patient representative and the physician, nurse practitioner. Unlike in Michigan, where a DNR can only be signed by the physician, the post can be signed by mid-levels, advanced practice nurses, and the patient representative may fill out a Michigan post if they're not able to make healthcare choices due to illness or injury. So that is new to Michigan. It's caused a little bit of confusion because it is freely available on the internet. And so sometimes we'll have individuals come into a facility that have an a durable power of attorney for healthcare or a living will written in some form. And then they'll also have an MI post that might have different information on it. So people can come in with different authority and they may have conflicting information. And so what I would advise in those circumstances is making sure that you're looking at the most recent, that things were revoked appropriately. And this is true with any, whether it's Michigan, Wisconsin, or Minnesota. If you have competing advanced directives, whether it's DPOA, DNR, MI post, whatever the case may be, that you're looking at the dates, you're looking at whether things were terminated appropriately or voided appropriately, so that you're using the appropriate, and that they haven't expired, that you're really checking your documentation before you're relying on it, in order for someone to make healthcare treatment decisions. And I think that should leave us about 7 minutes for questions.
Great.
Well, I just
Thank
have
you
to,
so much.
just a quick question that we have, because I worked with you for a long time and I've really enjoyed getting to know you and then also working with you from the legal side of it. So with that, I'm just going to bring up a scenario really quickly, because when we work through immunizations and we know how important it is. And sometimes guardians have a different guardians or people who are able to make those health decisions for a resident may have a different thought process than their person that they're guarding, right? And so I had a incident where there was a resident who said no, that they did not want to be immunized for COVID-19, but the guardian wanted it. So the DON said, hey, can you hold this person down so we can just go ahead and give them a shot? So that becomes a little bit of an issue. How do you navigate those kind of conversations?
Okay, so and obviously holding a resident down to give, that implicates some other issues, resident rights issues that I would be concerned about. In that instance, my first thought would be like, does that resident have the capacity to understand that? Like, what is the actual authority of that guardian? And if the resident has the capacity to understand, the purpose and the consequences of the immunization, and I would approach it from that perspective, because again, CMS is looking at making sure that we're not taking away any more autonomy from the resident than is absolutely necessary. And so, if the resident is capable of saying no and understands the consequences of that decision, and again, that's where it goes back to that, are they capable of making this decision? Then, then we can move forward with either, complying with the resident's wishes at that moment, or deferring to the guardian if it's found that the resident really isn't capable of making that decision. Does that make sense?
Thank you very much.
Yes,
and that's a really good example of that all or none, that just because they're the guardian doesn't mean that they can have free reign over everything.
Correct.
I know I flew through that really fast and it was a lot to cover. So I apologize if it was a lot, all in one sitting, but I'm always open for questions. If anybody, has any questions, they can email me, or we can do it through however you want to do that.
We appreciate that. Tabitha said, thank you, Margaret. I appreciate the resident-centered approach taken in presenting this information.
Yeah, that is a key thing that CMS is looking at now with their regulations, is And you see that kind of that thread flowing through, you know, not just resident rights, but it flows through some of the other tags now as well.
Yeah, they're really taking a resident-centered approach through almost all of the F tags. You're not
Yes.
going to see that they're going to be, oh, well, that's okay. That doesn't need to be resident-centered. It really, everything should be centered around the resident, as it should be, because we're here for the residents.
Right. And not to go off topic here, but it's an important, you know, oftentimes when the guardian is, you know, demanding a specific, not to be, I sound like I'm really down on guardians today, but you know, when a guardian is asking for something specific, you know, like I want mom to have, you know, this meal, or, you know, whatever the demand is, we have to ask ourselves, is that what the resident wants, or what is best for the resident, or is it what the guardian wants? And, you know, in helping us make that determination. So, because I've had that issue come up time and time again, you know, and it, like with families, the guardian will say, I don't want this family member to visit. And, you know, is that because it's what the guardian wants, or is it because it's best for the resident? So.
I love that you emphasize that, because we have a lot of times residents, I mean, not residents, but guardians have sometimes the best interests of their family member. Like if their mom is a diabetic and they don't want the mom to have candy, but the mom is like, I like to have chocolate every night before I go to bed. It's a very reasonable request. So how do you, you know, navigate those kind of conversations and and make the guardian realize they still have a choice in that matter too. So I appreciate you saying
Yeah,
that.
it's all, everything is all about risk benefit balancing. You know, what's the risk of harm? You know, which battle do you want to fight? You know, and balancing, like, is it a good accommodation? Like, okay, we're not going to feed her chocolate cake every night, but, you know, a little bit of candy, it's not going to kill her. So
Thank you so much for presenting on this topic. I don't see any other questions
absolutely.
in the chat. I just want to let everybody know that before you exit the chat today, or before you exit this meeting today, please feel free to do the evaluation in the chat box to provide feedback on today's session. Once you've completed the evaluation, you will receive a link to download a certificate of completion. This is your only opportunity to complete that evaluation and receive your certificate. So please take a few minutes to complete it now, and thank you all for participating. I see one more thing in the, and then there's the PDF of the presentation as well as the event evaluation. We will see you 2 weeks from now, or no, sorry, on our next presentation. And thank you so much for coming today. Have a great day.